an estimate there in your books on page 10. I'll let Mr. Higgins go over that with you.
Yeah, basically the board had asked for a proposal to do survey of the works of the district. And this is to basically survey the canals and to see if they are in fact within the easements. I should have brought the surveyor here to present it, but as it turns out, the surveyor that works for Be a Man, who knows every square inch of PalMar, says he's interested in giving a proposal to do it. So I want you to consider this, but not accept it until we at least get one or two more proposals to do the same thing. It's important from the aspect of, I first asked, what's the board's purpose for doing this survey? But I now realize that for law enforcement, for instance, to end up enforcing no trespassing, they need to know where PalMar's boundaries are versus private landowners. Right now, it's wild, wild west. Nobody knows where anything is. So, with that said, I would like to, well, I'd be happy to answer any questions on the proposal, which was very responsive, because I didn't have a clear purpose, but he is at least saying, I'm going to survey the works of the district and define where the canals are and if they fit within the easements. But at least postpone it for a month.
Well, I'll go first. Considering the scope of this, I think we need to do a normal, get 3 bids. There needs to be some specifics. This isn't even signed by an engineer. I don't even know who the contact person on this is. So in the request, they really do need contact information, email information, who we're talking to, because this seems to lack all of that other than Bowman, and Bowman is a nationally recognized firm, but I wouldn't know who the local contact is because it's not even on here. So I think
They're a local firm, and they do work for Martin County, and they've done survey work out in PalMar, and that's why I went to them. But legal counsel brought up the question of multiple bids, so.
I would support that.
I had an additional comment, if I may.
Please.
Just reading through the brief description of the services that were offered, under optional was location of culverts, and I think that was something we identified in a meeting and said we'd like to have that as part of the survey. And with deference to the engineer, the establishment of berm or levee heights as an action point for, do we see erosion? Do we see wear and tear on those banks? And at what point would we say we've lost 2 feet or we've lost 1 foot or lost nothing at all? That, in my view, should also be included within the scope of work, is establish some reference elevations up and down the perimeter berm and levee. And again, I'll defer to you on that if you think it's an important thing that we have as a reference point or not.
Well, it would establish a point of reference, but there's nothing in the water control plan that sets the levee heights. They are just there, and that's it. But with time and traffic on the levees, certain portions, they are going to degrade, and start getting wider and lower, it is a flood protection measure to have a berm, but there's no established height. But if the board desires, we can get that surveyed to establish it as a benchmark.
I think that issue has been raised in the past, and whether that benchmark was based on elevation above neighboring ground level or a reference to the NAVD
NAVD is.
NAVD, thank you very much. Basically reference back to sea level heights, I guess, would be where the reference point would be.
Most of the major culverts have been surveyed, and they were done under BMAN for cleaning the culverts. And what we did at that time was establish water levels upstream and downstream to see if there's clogging. So I've got the culvert information on the primary culverts. Now, you can start getting into secondary culverts, especially the ones that are from private lands into the canals. There's hundreds. I don't think it's a wise expenditure to go chasing after all those culverts.
I'm for establishing some reference points, and the elevation to me tells us when, perhaps TJ's in danger of not being able to drive the roads anymore. Otherwise, it's subjective. We just look at the roads and say, well, yeah, they're not as tall as they used to be. So having some standard to work from always helps me.
I have another point. In the agreement, it says that Higgins Engineering is the client. Who's the client? PalMar Water Control District? Or is he our agent and we're the client?
Well, I believe that this survey proposal was procured under Mr. Higgins' responsibility as the engineer under 298, which requires that the engineer does surveying work for different aspects for the water control plan. But to me, that the client ought to be the board, because the ultimate, that the scope of work is going to be set by the board in conjunction with the engineer, in coordination with the engineer. And I think the engineer is going to be heavily involved in things, but there's no reason why at every, all these contracts, they need to be, contractors need to answer to the board, not to individual, also our contracts.
And the ultimate product should belong to the board.
Absolutely. The board is paying for it.
So I think that's one change, and another is I'm, in no hurry to get back. I think we should have at least 3 bids if we can get 3 bids. It doesn't have to, if it doesn't come back in a month, okay, we'll do it the next month. I think it's important to do this right and comprehensively and to make sure that we get what we're looking for.
Yes.
And at this price, so, in previous meetings, we had talked about doing this. We didn't have any real reference for how much it was going to cost. Mr. Higgins got the estimate, and having it come in, and I would, I don't know if Ruth knows off the top of her head, but I believe at this level, we would want to do an actual public bid where we would actually advertise and everything too. I would, recommend that for anything of this size. So with those type of public bids, the board would have to authorize us preparing the bid package and going out to bid, and we would have to set kind of typically we want to give bidders at least a month to get a bid back, and then taking into consideration, we like to have everything a week before to be able to post online for the upcoming meeting and what have you. We would want the board to kind of give us some direction on kind of what month would you want to target as far as the meeting that you'd want to look at these bids. That will give us we can back into the time frame for doing the advertisement that way.
Yeah.
Let me interrupt to say that the reason why it was structured as he did was because of CCNA, which is the Consultants Competitive Negotiation Act, I was selected by this board through CCNA, and I could hire subs. And so that's what he did. Now, if what Michael just outlined is setting it up to do a CCNA advertisement where you'd get multiple, and they're not bids. It's not price oriented. It's their reputation and whatnot to
Select.
You're talking about an RFQ instead of an RFP?
yeah, it's an RFQ, which is fine.
Okay.
Which is fine. We can open it up to multiple firms.
I'm good with that. I'm familiar with Bowman. They do a lot of work for Martin County. They're reputable. I
Yeah.
just think that it's in this case, because of the board, because of the importance of the survey, it's probably a good idea to do an RFQ.
That's fine. We can do that.
All right, so if we were going to do the advertisement for an RFQ, so just to kind of give the board an idea, your January meeting would be January 4th. Your February meeting would be February 1st. Do you have, and then, just so you know, your March meeting isn't until March 7th with the way that the weeks fall. So do we have kind of a target meeting where you'd want to be able to talk about this so that we can back into the timing of how long to give the bidder or the people to put in a qualification?
February's good, right?
I don't think, well, first off, I really don't think we need a meeting January 4th.
Okay.
Yeah.
Yeah, that's a tough one. That's usually a hard
I have
one.
a
Yeah.
zoning meeting, but I don't think, there's not going to be much done between now and January 4th. So January 4th is, we can, even though that should be later in the agenda, but since we're talking dates, I think
Pardon me.
February, did you say, what day in February did you say?
February would be February 1st.
Nope.
Okay. If it's doable, I think that might be the best case.
Yeah, because I think, Bob, you think a month, we give them a month to respond. If we're doing February, we can get the bid out in a couple of weeks, give them a month to respond. We should get it back in time for that February meeting, yeah.
And that allows sufficient time for you to develop a scope of work that they would bid by and the board members to review and say, yeah, that works.
So this would not include a scope of work. This is just their request for qualification.
Qualifications, right,
Okay.
yep. Correct. All right, so,
Make sure when they are doing their scope of work, that they actually have a complete, this went off of Exhibit A. I just want to make sure that what they're bidding on is complete. Exhibit A has a couple of things that's not on it, so we'll get the request for qualifications, and then we will outline an RFP.
all right, so we would be looking then for a motion from the board to move forward with an RFQ with the intent of bringing back the results on the February 1st meeting.
So moved.
Second.
We have a motion and a second. All those in favor?
Aye.
Aye.
All those opposed? Motion carries. RFQ for. All right, so yeah, I'll get with Bob and we'll get that advertisement out. All right, moving on to new business. Consider designation of district secretary and treasurer. So as it stands right now, I am your district secretary and treasurer. I know that most of you before the meeting, I introduced you to Andrew Camaris. I don't know who Richard Camaris is. Andrew Camaris here in our office. He actually sits right next to me in the office. He's going to be, after this meeting, he's going to be taking over as your district manager. So I wanted to bring him here tag team today so we can kind of see how the board runs, and then it'll be his baby going forward, with obviously me being there for any questions he might have, especially for historical stuff. But as kind of a matter of housekeeping, this would be this resolution 2023-04, which is in your books on page 13, basically switches over your district secretary and treasurer from me to Andrew, so that he can take your minutes, and he can also sign for anything that we might need him as a treasurer, as far as the things, bills and what have you back at the office.
And Ruth, have you gone over this? Is everything okay?
It seems everything is okay. I just want to make sure that the folks who are identified, Todd Wodraska, Jason Pierman, Patricia Lacasas, and Andrew Camaras, just make sure that those people have full authority to do everything that Andrew is going to do in the future. Is that right?
Right. So in our office, especially for bill pay, we use a system called Bill.com, and as a matter of practice, we have multiple steps of approvals before those bills can get those payments can get sent out. So we have to have multiple people with the same authority in case Todd might review it one month, but then if Todd's not there the next month, we need somebody else who has the authority to review the bills and approve the bills before they go out. So this just gives us redundancy in the office for people being in and out of the office when bills are needing to be paid.
I'm satisfied. Move approval of resolution number 2023-04.
Second.
All right, we have a motion and a second. All those in favor?
Aye.
All those opposed? Motion carries. All right, moving on. Consider resolution 2023-04, which is authorizing electronic approvals and check signers. This, again, is kind of the same thing. This all goes part and parcel with us switching over.
We already approved that.
Oh,
We're on 2023-05.
sorry, 2023-05, adopting record retention schedule. My mistake. So this, earlier in the year, the Florida statutes were updated to allow for some things that used to be required to be actual paper retention, we can now do as electronic retention, reducing the need for boxes of paper sitting in storage doing nothing for certain documents. As part of that, it's been our practice with all of our other districts to go ahead and get the board to officially adopt, even though the statute has been changed to allow for it, to have the board authorize us to go ahead and move forward with that type of retention. This resolution basically goes over that ability, and it also has the board kind of officially declare that you can use the electronic version as your official version. With that, I'd turn over to Ruth if she has any other additions she wants to make explaining the need for the resolution.
No, I think it's a good thing. It's not necessary, like Mr. McElligott said, but it's also good to keep as one of the foundation documents for next year's policies and procedures manual that the board has directed that we draft.
Who's our records management liaison officer?
So that would be our office. Right now, we keep all the records, except for, we keep all the electronic records right now. We have a server, we have a backup on-site, and then we also have an additional backup off-site for all our electronic documents. Ms. Viator, your old attorney, still has some of the old physical records that the attorney had. We're actually going to talk about that in another agenda item about getting those records finally turned over to your new attorney. But so we would be the records liaison for, especially for all the digital documents.
Unless there are any further questions, I'll move approval of resolution 2023-05.
Second.
All right, we have a motion and a second. All those in favor?
Aye.
All those opposed? Motion carries. All right. Item number 4, consider approval of rate increase for Higgins Engineering. This is in your books on page 18.
Number 3 is consider resolution,
As we just did 3.
I'm sorry. So, 1, 2, 3, you're right. Okay, thank you.
Yeah, I think what ended up happening is 1 and 2 basically got joined together.
Correct, thank you.
Because it was kind of for the same reason, so we kind of did all in one discussion. Moving on to item number 4, consider approval of rate increase for Higgins Engineering. His proposal is on page 18, and with that, I turn it over to Mr. Higgins.
Yeah, I was first retained by PalMar in 2008, and the rates were actually low. It was a Scribner's error in the original contract, but that, aside from that, had taken a look at the CPI between 2008 and today, and that's how I arrived at the proposed 2023 rates. I don't expect to ask for an increase for another 10 years, but it's been quite a while. And I knew that with lack of funding for PalMar, it was kind of hard to end up saying, hey, give me a pay raise. So here we are. I think we're not fat by no means, but these rates are, and as Andrew and Michael can attest, are probably comparable to what other district engineers would be charging.
Yeah, agreed.
Just kind of going backwards in time a little bit, we had a past budget item at $26,000, I think, approximately, for engineered services. So if we use the multiplier, that puts us at about $37,000 for the upcoming budget. Other factors that I had, and just kind of going from construction experience, managing engineering cost is sometimes part of a contract, and I would like to understand how your services in total are provided. Is it strictly by the hour approach, or does your estimate for engineering to support the district also include normal evaluation, condition of the works, et cetera?
It's 100% hourly, and it's at the direction of the board. So if the board gives me a task, it gets billed hourly. And the support staff, the other ones, are minimal. It's primarily me that takes care of PalMar.
Okay. So in a stagnant district, the exposure for substantial financial impacts would be minor, but if there is some future occurrence that occurs, should we be prepared for the financial impacts that brings within our budget?
Well, typically a board, when it gives an assignment, will decide, well, it's not significant, just go do it.
Yeah.
Or come back next meeting with an estimate. And that can always occur.
Okay, that's all I had.
Anyone else?
I have a question, if you could. Does that mean that we pay you by the hour? We don't have a flat rate for a meeting or anything? In other words, okay. So if we're here
If the
3
meeting
hours or
lasts,
6
if
hours.
the meeting lasts an hour, it gets billed for an hour.
Thank you.
If it lasts 3 hours,
Understood.
Oh, boy, sorry, one last question, but cost plus in contracts. Do you have a system that you work for? Say that the survey was a good example at $265,000, falling under your responsibility as one possibility, and then falling back to PalMar as the others. If it were to fall under your responsibility, does that just pass through billing, or is there
yes.
a markup overhead profit that you use?
I've never done that.
Okay, beautiful. You're very generous, I would say, compared to most of the engineers and contractors that I am
I
familiar with.
understand how it works.
Thank you.
Mr. Stokes?
Yeah, I'm trying to better understand. I had asked Mr. McGilligoff for the contract, and it appears like the last time, I guess my confusion is, the original contract was done in '08. Have we publicly advertised this per CCNA since 2008?
It was done in 2008. Yes.
So you didn't, so no, the answer is no. It's been since 2008, since we've re-advertised the engineering contract.
Correct. Yeah, that was the last time it was advertised, was 2008. There was an amendment to the contract, but that was for terms. It wasn't for price or anything a couple years ago.
I mean, it's not that I don't, it's not that I lack confidence in Higgins Engineering, but my concern, and I'd like to go more to the legal, is, I know in my world that I work in, that we go out at least every 5 years, there's a CCNA re-advertisement, and I'm wondering from legal's perspective, if that's something we ought to do. I mean, it's 2008 to 2023 that's a long time since not re-advertising.
So Higgins Engineering's last contract amendment authorized that it be a year-to-year, an ongoing contract, automatically renewed every year. Is that right,
Yes.
Bob? Okay. So I think, Mr. Stokas, that if the board would like to put parameters on contracts, then I think it would be subject to, some kind of motion and approval by the board, and it could be something that is in next year's policies and procedures manual. So it's very clear from the outset, this is what's going to happen every X number of years.
Mr. Stokas?
Well, basically, what I rely upon from year to year is my knowledge of the district and the history. And so I'm not afraid of going through CCNA, but I'm not sure you'll find another engineering firm that's got the knowledge and background of PalMar.
As many times as I've tried to stump you, you're right.
Yeah.
Yeah, my concern is not necessarily the knowledge. I would not disagree. I think you're probably the most knowledgeable engineer around on PalMar. My concern is when we are faced with other engineering firms saying, well, I can do it cheaper, or it's not fair because I haven't had a chance to advertise it. And those may be unfounded, but I almost feel like we should at least just advertise it, similar to what we're doing with the surveyor project, and that way we can use that to hide behind. And then maybe in the next discussion is, what's the rules and procedures? Should we be doing that every 3 years, every 5 years? So, I mean, that's kind of where I sit on this. But I'll leave it to the board majority.
But that's why I said it's an RFQ and not an RFP. I'm not afraid of it. I mean, this is not the cornerstone of Higgins Engineering.
No, and I don't, no disagreement on that.
The general knowledge in the past, probably 10 years, has always been that Mr. Bob has always known what is going on, and the other attitude from the previous board members was that we're so small, we didn't seem to get anybody else interested.
Yep.
Just to put that
I
out.
think there was 2 proposers in 2008. That was it.
But I understand where you're headed to, George.
Whoever wants to
It only makes sense.
Well, no, I'm going to ask Ruth, what would be, in our position, what do you're our attorney, what would you consider our procedure should be today?
Well, I think it's, there's no harm in re-advertising competitively, every X number of years. And if, for example, like Mr. Stokas was saying, Martin County does it every 5 years, I don't think that's a bad thing. The downside is obviously the cost and the time that it takes for the board to go through the competitive bidding process every X number of years, and then to keep track of that. So, there's some practical administrative aspects to it, each way you look at it. But, I will say it from my perspective, I've known Mr. Higgins for a long time, and there aren't very many engineers that I know of that have the comprehensive understanding of water management in South Florida as Mr. Higgins does. There's a few.
Thank you.
But I don't know at $250 an hour if they're going to bid. But that said, if if the board desires to at least see what's out there, just like you could have done with your general counsel, like you could do with any of these contracts, with your district manager, you can see what's out there. And it might go a long way as to satisfying, that you're at $250 an hour, that's a good rate for the board for his work or anybody else's work.
Any more questions?
I'm very familiar with CCNA. I know that you pick your consultant based on their knowledge and ability, and I absolutely agree with council. I think Higgins is one of the best for South Florida water management items. My concern is in 6 months when we have another engineer roll in here and say, oh, well, I can do it for $200 an hour. I'd like to be able to turn back to him and go, okay, well, why didn't you propose? If you think you have the same knowledge as Mr. Higgins and you could have done it cheaper, why didn't you propose? That's kind of where I'm at, but I'm good with wherever the board wants to go.
I don't feel that there's a compelling argument being made for either side, so I would prefer that we kick the can down the road.
Is that a motion?
I hope not.
Motion to kick can down. I don't think that's, we're not going to do it that way. So the item kind of before the board at the moment is the
Approval of the rate.
approval of the rate increase, right?
I'll make that motion to approve the proposed hourly rate to $250 an hour, and the engineer and junior engineer, draftsman, and administrative.
Second.
Was that you? Okay, we have a motion and a second. All those in favor?
Aye.
All those opposed? That motion carries.
Thank you.
All right.
Okay,
Moving on to item number 5, consider approval of mowing proposals. So these proposals begin in your books on page 19. To give you a little background, your maintenance supervisor was able to go out and get a couple different bids. One of the bids is from Tim Wallace, the guy that you guys had approved to do the big mowing last year, which was, the first mowing in 5 or 6 years, whatever. You'll notice there's a loose leaf of paper in your books from South Florida Bush Hog Service. The proposal is the same amount. They just realized after we had posted the books that their description wasn't wholly accurate. So the only real difference between the one in the book and the one that's a loose leaf right there is their description of how they're going to do the work. They just wanted to make sure that they were a little bit more clear on that. With that said, I'll turn it over to TJ to kind of go over the different bids that he got.
Good morning.
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 Yeah, I got these bids. I saw the bids for the first time Monday when this book came out. I looked on the computer and I saw what his description was, and I gave him a call then. I said, you need to take care of what it is. As far as you're telling me, you're only gonna do hungry land banks. And so I more or less told him on that. And like I saw from last year's bill and everything like that, I knew what I could do. What I told you all I could do is find somebody who was cheaper with the right equipment. These tractors will do the job very fast. They're good companies. Quality here's the one that gave me this other South Florida Bush Hogs number. And apparently he does other jobs for Michael's company for other people. Quality does.
Yeah, A Quality Bush Hog has a couple other districts that we manage.
Yeah, and they all seem to know what they're doing and know what I expect. All I expect out of them is a good job and nobody coming in here saying it's a crappy job, and I inspect it. And I told them all, they don't get paid till it's done, and if I'm not happy, that's what's gonna happen. And so far, when I worked there before, everybody was happy. It was beautiful out there after the mowing. And that's what I expect out of these new mowers. So I like it all. It's up to you. I don't want to say much because it's up to you, and I was very happy with it.
Thank you. I actually do have a couple comments. I think we need to have guidelines. When we're asking for proposals, we need guidelines. Name, address, phone number, actual signature of the person. Attached it should have their insurance license, workman's comp, maybe previous work done, qualifications. This is on this bid, and I realize it's a nice bid for $39,500. There's still not a contact person name on here.
Right, so what I will let the board know is this is just TJ going out and getting proposals. This isn't, we didn't actually go through the formal bid process for this because of the lower amount that we were looking at. So in an actual bid process, we would have done all that. This is TJ looking around and finding who can do it and what are they willing to do it for. We would obviously get all that stuff in a contract, and the contract would come back before the board to be signed with all the backup information. But I agree.
Couple of comments. One area that was new to me, perhaps I missed it, but the FWC lease area is also included in both mowing contracts, is that correct?
Yes.
All right,
Yes.
We're talking about the main canals?
absolutely.
That's part of the.
Yes.
Yeah, I didn't find that clearly specified.
Microphone.
Microphone.
I did this for 9 years before this. I was off for 5 years. When I came back, I took John out there from Quality Mowing, and I looked at what they didn't mow last year because of the taxes and stuff. I called up Michael before I took anybody else out there to find out if they paid their taxes, FWC and water management and all that. And he told me yes. And I told him that I used to mow all those canals, all of them, every bit of the works, all the outside berm, everything. And he says, well, I'll check on that. And I had him check on this. And I did used to mow all that because apparently somebody's saying I didn't. I did.
Oh, no, we're not.
I remember,
I'm agreeing with a comment that Ruth
Yeah.
put forward.
but
Basically,
we mowed
dot your
all of
i's,
that.
cross your t's, that's all.
Yeah.
And if it's not clear in the.
Well, I did do that with Mike. I called him and I said, let me know what you want me to do. And you did what I asked. And then I took other bidders out there. And I drew a map and I marked it all up, all where the works are with a big marker pen. I said, this is what we're gonna be mowing, this is our works. And it's what I did when I was here before.
Your understanding along with the paper clarifies it a little bit more, but I'm much more comfortable when somebody details it in writing and.
Well, I was gonna, I just came back to work.
Okay.
If I had to do this every year, which I was very happy with my last mower, and that's who we kept. And this is what I tell, if you do a good job, I will put in the word for you to be the next mower. If your prices don't go crazy. And that's what happened. I took it over and I knew how to get them. I went to places where they sold tractors. I said, I'm looking for a mower. Do you know companies? And they gave me phone numbers. And I called them because that's what you do. But,
No, we're not questioning, we're not.
Yeah.
questioning that. We wouldn't be doing our due diligence if we didn't have more information.
yeah. Well, I plan on, if anything, I thought about it, I'd put a big scope of work out of what I need there. I want to know how many machines they're planning on bringing to the job. As far as insurance, all that, whoever you decide will have to go through Mike. And this is always done, always. They have to come supply their workman's comp, their everything what it takes, their licensing, everything before it comes back to you to sign, to okay. So,
Thank you.
I would like to add an additional item to the mowing contract, or an additional item for clarification. Brush removal, heavy brush removal and invasives, it was kind of mentioned in there, they were gonna mow some,
Hollies,
some holly.
anything what, when I tell them, I say, if it touches your truck or it's about ready to touch my truck, I want it cut back.
And
I want the hollies cut back. They don't remove nothing. They got those bank cutters and they chop it.
they do, they absolutely do. And the point I'd like to make is that in chopping holly in the wrong time of the year and then grinding those seeds up with a heavy-duty tractor tire, alls we're gonna do is spread them.
Well, I've done-
Worse than the birds will.
That's the way it's been done since we've been there.
Maybe
everybody.
we should consider getting a licensed sprayer or a more thorough removal of that bush.
I went through all that when I was there before. I thought of spraying till I looked at what, that would cost $500,000 to have somebody go in there and spray and kill hollies. It's just crazy prices. And what we did is cut it, when I cut, this is why I cut in January. Most everything is dead. And everything's already fell. There's nothing we're gonna do about seeds off of anything. Once we cut that all back, it's all, and I used to do that every other year. I didn't do it every year. I went to, and I told the mowers when they were my steady mower, I said, you gotta put this in your price. If you're not gonna lower the price of cutting these back, make sure you lower the price to where it's covered. You're gonna get the same price every year, which before when I had it done for $32,000 a year. And that's a lot of mowing out there for $32,000. And it was beautiful. I mean, now we got trees growing up in Hungry Land on the banks. I mean, I got big pine trees.
Oh, absolutely.
And, there's a lot more to it.
I think I'll defer to the engineer's comments on this one, but my personal experience is only managing 5 acres, cutting hollies and grinding the seeds up and not killing them is, to borrow an engineering term, kicking the can down the road. And it will only cost us more in the future if we do not address the problem reasonably, to some degree now. A limited budget? Do we put 10,000 in for a spray company to come in and take out some of the invasives for it? But a managed approach to keeping those invasives back and controlled, that's all. And it just as a scope inquiry, pardon me.
What I have seen, and occurs in the adjoining Hope St. Lucie Conservancy District, the big cost is the initial. And then to maintain it is reduced. So if you average that out over 5 years, it is actually economical to do spraying versus mowing and chopping them down, because it will come back.
So, Madam Chair, I'd like to make 2 motions. One, that we move forward with South Florida Bush Hog Service Incorporated based on the quote of $39,500. And then I have a second motion after that.
Do I have a second?
Second?
All in favor?
Aye.
Any opposed? Motion
Opposed.
carries. Opposed, okay, 4-1.
And then, Madam Chair, I'd like to make a second motion. I'd like for, staff, with the assistance of Mr. Cutting and our maintenance manager, to go out and look at cost, size, and scope of the exotic removal process that we're discussing today. I feel for me to make a good decision, I'd like to see more of the full financial picture. We've got quite a few logs in the fire. We're looking at surveying, we're kind of reorganizing the mowing. And before we undertake an extensive exotic removal program, I'd like to know kind of cost, size, scope, breadth of the project. Maybe staff can bring that back in the first calendar quarter of next year, and we can talk about that. But I also, if Mr. Cutting's a favor, I'd like to nominate him to be our board representative in that effort.
Oh, joy. Thank you for that.
Would you accept?
Hey, I did the legal counsel. You can do this one.
Is a lot of this on private property?
A lot of it,
Yeah, I'm,
probably 95%.
I'm not talking about anything on private property. I'm only talking about what is
Right-of-ways. Yep.
on the right-of-ways or growing on the canal.
That's
banks.
still, yeah, it's basically going to be canal banks. That's it.
That's why I believe it to
It won't be the outside.
I believe it to be a minor cost impact, not a major cost impact.
It's on the outside.
Some is,
On the berm,
absolutely.
but it's really not all of them.
No, it isn't.
Like, but, I mean, poison is just extravagant. I mean, but you'll hear what the prices are, and they're just, because I thought of that, I said, this would be a lot easier just to poison everything.
Yeah.
But it's a big nut to crack.
Well, I think if we don't
Look at
get
it.
an estimate, we have no idea. So I think that's,
So that's my motion.
And are we talking spraying or are we talking manual removal? I'm not all that thrilled about
It'd
spraying
be
either.
spraying. You can't-
Glyphosate? I'm not thrilled.
Hope not.
In terms of
That's the spray that's used, or something worse.
Florida holly, all you're doing when you're chopping it back is you're just chopping off branches.
That's what I'm asking. Is it going to be machine
No, it will-
removal, or is it?
That's what I'm talking about.
There are two techniques. That one is completely remove it, dig it up, and make it go, which is very expensive and will result in erosion to the canal banks and repair efforts, et cetera. The second would be cut and spray, so that we're not spraying an entire massive tree, we're spraying a stump in a very controlled way. And, you're right, the chemicals are of big concern today. But, again, if you don't find some way to reasonably check the growth, there'll be a time when we are overgrown, when, this will become an extremely expensive endeavor to control.
I'm not too afraid of that, but it is the best control method is the hack and shoot, which is just cut into the base and shoot it, inject herbicide.
I'd like to look at both methods, cost of both methods.
Okay.
Well, I've thought of bringing in a loader with a rake before, because it's not on the canal banks, it's on the berm. And it's growing over, which it's only in a couple sections that need to be cut back. And bringing in a rake on a loader could just pick the whole thing right out of the ground, and it's not gonna do any erosion on the water bank.
I think, Madam Chair, for me, I am not a holly expert, even though right now it's December. I'd like our maintenance, I forgot your title, TJ, but I'd like TJ, Mr. Cutting, and our engineer and other staff to get together and give us the two options, the cut, their cut and spray or the manual removal, and let's have a discussion about it, next year.
Works.
Do we have that as a motion? Do we have a second for that?
Second.
All right, so we have a motion, a second. All those in favor?
Aye.
Aye.
All those opposed? That motion carries. So as regarding the approved proposal for South Florida Bush Hog, what we'll do now is we'll go back to them. I'll get a contract that our attorney will look over. We'll get their insurance and get all that in order before we authorize them to do any work.
Thank you.
All right.
Next
Moving
item.
on to item number 6, consider formal request to abandon a portion of an easement. This is in your book, starting on page 22, and I will let Mr. Higgins go over this one.
Yes, this was presented to me, I guess a couple of weeks ago, and it is not a canal easement. It is one of the thousands of roadway easements connecting parcels. And this is up in the Chimney area. And the first thing I asked was, okay, do you control all of the parcels that the easement's being released? And BMA responded, yes, they own all of those parcels. Is there ever going to be a roadway built there? Not in my lifetime. So I can't be opposed to the release, but I don't want to necessarily support it with the understanding that this is probably the first that's been released.
This parcel is in Martin County. We've been asked the same question. Can I get our legal department to respond?
That's fine.
Morning.
For the record, Senior Assistant County Attorney. As you all may know, a lot of these easements came out in the late 60s. This one specifically was in 1969. It was dedicated. However, from a legal standpoint, there has to be formal acceptance of any easement, and we've seen no evidence that there's been ever any formal acceptance by the county of these easements. So it's the county's position that we can't abandon something we never accepted. And that's the long and the short of it. And it's also, these easements are a topic of litigation that the county's in. It's about as much as I can say on that.
I will opine to end up saying they are recognized, though. In other words, if you did a title search on any of those parcels, that easement would show up, and it's an encumbrance.
They're in the deeds. They are in the deeds. But I can put things into my deed, and it doesn't mean anyone accepted it. I mean, it will follow my chain of title every time I sell my property. But again, there has to be formal acceptance of any easement.
My apologies for not reading in advance, but does this fit that generic description, utilities, roadways, and drainage incidental there too?
Yes, sir.
So the only thing that, I mean, we can't abandon what we don't own, as you say.
It's an access easement for the purposes of listing those parcels for sale with TIF. And it's a requirement to have legal access. And that's what that easement is for.
Do we in any way own, regulate, or control the access easement?
No.
We only would have interest in the drainage portion of that.
But PalMar's caught up into it just because of the dedication language. That's all.
Madam Chair, I'm confused because our engineer is saying roadway, but the applicant is saying drainage. The Exhibit A, number 4, says drainage.
That's drainage incidental to,
Yeah,
Oh, okay.
which is different than a canal.
call it a generic easement, but yes, it lets you put telephone poles, a ditch, or a road.
Utilities.
Yeah, exactly, yes,
Well, and
gas lines.
I guess from my other position, and another question I had is why would a drainage district abandon a drainage easement? Whether it's incidental or not, you still,
Well, when it says drainage incidental to, it means, okay, the roadside ditch or swale would be part of, in that easement. It would not be a flowage easement. But again, I'll say I'm not supporting it or opposing it. I think there's no harm caused.
I would suggest that we throw it to legal for opinion. Do we have an abandonment authority, or?
Okay, so there are a couple things with this. Number one, I was never asked to look at this. This email from the corporate landowner to the engineer dated November 22nd, I didn't see this until it came out in the agenda. And so this is the third time I'm bringing this up in this meeting about next year's policies and procedures manual, because how this got on the agenda, and we're all kind of looking at this and scratching our heads, wondering whether or not it should be done. The very first question we have to ask is whether or not this thing is valid. And, we all know that there's an ongoing lawsuit brought by the corporate landowner against government entities about the validity of certain easements and what they mean and the interpretation of them and, everything that emanates from that. So to me, it's kind of almost a gotcha moment to be discussing this easement and whether it ought to be released without a thorough review of it. That's number one. Number two, just as a practical matter, it's not a legal issue necessarily, but if it is a valid easement and the board does want to somehow say, you know what, we don't need this anymore for the purposes of our water control plan, why is there not compensation on the table for this? That's something that needs to be discussed as well, if it's determined that it's a valid easement. And the third thing I would go back to is just, again, this seems to be subject to whether or not this is a proper procedure to be on the agenda today.
How did it get on the agenda?
I received an email from the engineer to place this item on the agenda.
Where did the engineer get the email?
Yeah, my apologies for not sending it to Ruth at the same time. We're in a transition period, so obviously I should have sent it to her also.
Madam Chair, I'd like to make a motion that we postpone this item until our legal counsel has had adequate time to review and make suggestions and conversation.
Second?
I'd like to add my 2 cents. I don't think it's in the best interest of the district to give up any rights. That's just my 2 cents.
My turn, if I may.
Please.
Thank you. Procedurally speaking, what is the standard? Is any property owner allowed to approach the engineer with a question that, I don't know, maybe he's got to spend 10 cents on the issue, maybe it's 10 hours? How does that fit within the district? Or does the landowner bring it to the board and we all say, yay, nay, let's invest in solving this problem? What is the procedure?
Well, I would venture to say that it should come to the district manager or the board before it goes to the engineer, especially if we're paying $250 an hour for something that we end up not needing or wanting. So there should be an order of priority of how something gets on the agenda and what time and effort is spent investigating it. But I will look to our attorney.
So a while back, I had asked the question when I was in the Martin County seat, not here in this one. But I asked the question of Mr. McGilligot, what is the procedure? What is PalMar Water Control District's procedure for putting something on the agenda? And what I recall, and this is going back
Couple of years now.
couple years, the answer was an item could get on the next agenda if it's brought up by one of the supervisors and it's approved to be an agenda item for the following month or the month after that, or it's a special request from the chair. And so
Neither of those were the case here.
right, and the whole point of that was, and well-founded, was that, the staff or the people that you've hired to work with you on engineering issues, legal issues, maintenance issues, that we have some time to thoroughly review this so there can be an actual discussion with the board, a knowledgeable discussion with, making sure that we understand what the issues are, we can present them to you, and there could be, actual thorough consideration. And that was the purpose of it, which seems to be
Right.
pretty good.
Yeah, basically, we've never had a formal policy. As the board is aware now, we don't have very many, if any, formal policies. What had happened is in years past, it got to the point where there were some board members who would like to try to send the manager an email a day or two before and get stuff on the agenda. So the board, while they're not going through the official policy process of creating an official policy, made it kind of a board rule that if a board member wants to add something to the agenda, they need to bring it up at a prior meeting, or if it's like an emergency type situation, the chairman can approve something being added between meetings to an agenda. The thing that's never really come up before is if staff wants to add something to the agenda, I've always just accepted, if the attorney or the engineer ever sends me something and says, hey, can you put this on the agenda? I always just go with putting it on the agenda if it's coming from staff. So I agree with Ruth. We need the policy to be we need a policy to begin with, an official policy, and it to be clear that, do board members and staff get treated the same, get treated different as far as adding things to the agenda? But there's never been a situation before where the staff, I had a problem with staff adding stuff to the agenda.
Is there a motion?
Great. Mr. Stokas was going to made a motion to table this item until staff has had more time to review it.
I'd like to amend that motion that this is brought back up at the next meeting.
I'm
see an opportunity here.
uncomfortable with that because of ongoing litigation with Martin County. And I'm also an elected representative for Martin County. So I would oppose that amendment. I don't know how appropriate it is for me to be voting on this one, to tell you the truth.
There is
I just want to leave the timeline in the capable hands of our attorneys. When she's ready to come back and discuss it, she'll let us know.
Might I make a suggestion to try and stay in line with what the Water Control District's kind of unwritten policies were in the past, according to Mr. McGilligot? Would it be something the board would be interested in if, once that we take a thorough look at this, I take a look at it in conjunction with Mr. Higgins, the engineer, and then before it goes on the next board agenda, that I run that through the chair and make sure that the chair is comfortable with the timing of it, and then the chair reaches out to, I guess at that time it'll be Andrew, and get it on the agenda at that time, if that's a good procedure. If not, it's just a suggestion.
Are you okay with amending your motion to such?
Yeah, to the chair? Yes,
As far as when to table it and bring it back once it's been reviewed and ran through the chair?
propose, the motion maker agrees to the suggested language by council.
Seconded.
And I'd actually like to comment, procedure-wise for the agenda. I believe that the chair should also have, the agenda shouldn't just be sent without input from the chair. So in the future, I would like to see what the workings of the agenda are before it gets printed.
Okay. So right now, the statute has us post the agenda 1 week prior to meetings. So then sometime in that, between 2 weeks and 1 week, we would send it over to you and have you. And again, this is probably something that will be good to be part of our policy conversation in a couple of months. But at least for the time being, unless there's an objection from anybody on the board, we can at least do that where we send you the agenda, after the 2 week period, but before we actually post it. Any problems from the rest of the board on that? Everybody good with that? Okay. All right, so then the current motion is to table this item to allow the attorney to review and for the attorney to check with the chair before bringing it back on the agenda. We have a motion second. All those in favor?
Aye.
All those opposed? That motion carries.
Thanks.
Thank you.
So should we have a motion while following on to this, that we have an agenda item to establish policy for putting items on the agenda?
Well, we have a standing, Mr. Stokas made a request at, I believe it was the last meeting that we had in October, to have sometime in the first quarter, so either February or March, to have an actual agenda item to talk about policies for the district in general.
Okay, good.
So I think this would be perfect for that.
Mr. McGilligot, is the staff clear then, I guess, based on the discussion we just had, that for example, if you don't get to the policy till March, so in February, you're going to be working with our chair
Right.
the 2 week to 1 week period? Okay.
Right, yeah, so until we have an official policy, the kind of standing policy of the board, although we haven't gone through the policy-making process, standing policy of the board is right now, until further notice, to run through the chair for the agendas.
Okay, thank you.
All right, moving on to item number 7, update on proposals for washout repairs. I know I spoke with TJ prior to the book getting posted. He's contacted a couple different people. Right now, it's one of those things where the job's a little too small for anyone to really have time, especially during the holidays, to want to come out and do it. So this may be something that he's got to continue to try to find. I'll let TJ comment further.
No.
I got some numbers for people and everything like that, and I've talked to a couple of people, but they never returned my phone call, and there's few washouts there, but in the past, there's nowhere near as bad as what has been in the past, and when we get to my turn to talk, I'll show you some of the problems of some of these washouts. Somebody has fixed the washouts at that crossover. Was done on Friday. It had to have been done, I think, right after Thanksgiving, because I was there Saturday. And there was bobcat tracks where somebody's fixed it at that crossover. My problem was trying to find somebody with an arm to clean that dirt out of the canal. And they just fixed the washouts there. There's a few more. There's probably maybe 10, but they're livable. And it's, I'd rather get it mowed. I'll get somebody for there, but it's just so piddly, they don't want to mess with it.
Thank you.
Thanks. So he'll keep working on it and update the board in the future once he actually has somebody to get out there. So moving on to item number 8, discussion regarding termination of Martin County Sheriff's Office agreement. So since the last meeting, when Officer Smith was here, and before this meeting, I received an email from a gentleman that I wasn't familiar with, Mr. Romero. The email is in the books on page 33, explaining that basically due to staff power and resources and what have you, that they were no longer going to be able to continue the off-duty work detail that we had been doing for the last couple of months. I did check. So my contact was an officer, I believe it was McDonald Thomas. I forget his exact last name, but I checked with him, the guy who we actually went through to get the original contract signed through, and just to make sure that this was what we had been having done out here, and he said yes. Basically, it came down to the people doing it, manpower, resources, what have you. So at this time, we no longer have Martin County Sheriff's Office out there. I can let the board know that since posting the book and everything, I did get an email from a private security firm who said, hey, if the board is interested, we would be willing to give a proposal. I told them that was premature, that the board hasn't even discussed this yet. But at this point, I'd leave it up to the board if you want to look at, doing something private, if we're okay with leaving things the way they are for now, or if the board has any other suggestions. But at this time, Martin County will not be supplying off-duty work anymore.
There was a suggestion made in the letter about FWC. Have we gotten any input from FWC?
No, I have not contacted FWC yet. I wanted to bring it to the board to see their pleasure as far as if they do any of the similar off-duty work. I don't have any knowledge if they do a similar program or not, but that's definitely an option. We can definitely, somebody from FWC here?
Would someone from FWC like to comment?
Morning.
Good morning.
Morning, Tom Ryan, Regional Director for FWC, for the record. And Madam Chair, thank you. I have spoken to one of our officers who does this. It is done not as an FWC action, it's done as a private action in off-duty capacity, just like the sheriff's office. And in fact, I spoke to him when this first came up and the board hired Martin County for off-duty. And I shared with him the proposal that had been put before the board, and he said, yep, that looks about right. I would charge it about double. And that was at the time. So I spoke to him, Officer Hudson, yesterday in anticipation of this meeting, and he said his company would be interested, but there's a variety of sideboards that he would have. And I think the prosecuting or policing trespass is a difficult one. He said we would definitely enforce state rules, things that we normally do, but it gets a little dicey when it's trespass on properties that may or may not be properly surveyed, et cetera. So I can provide Mr. McElligott and Andrew, Andrew, right? Not Richard. Which one?
Yeah, Andrew. Yeah.
Andrew. I can provide them with Officer Hudson's contact info, and they can reach out to him for those sideboards and a proposal if you like. I'm happy to do that, but that's what he told me yesterday.
I'm going to add to this. I did find the FWC's policy for private private use of officers. And I think you may have a copy of it. If you don't, I'll forward it. But basically, yeah, there's some liability concerns that the board would maybe have to be responsible for. That document, I think in general, just needs to be reviewed and would paint the way with our attorney to make sure that we're covered and we can do that. I go back, though, to that letter from Martin County. They used a word in there that is particularly concerning, and that is onerous. And they state that the officers could not do it because it had become onerous. That puts it in personal context. What occurred? Is it confrontations with landowners? Is it the fact that they did not like being the police and a nebulous kind of quagmire as far as who owns what lands, et cetera? That, I think, needs to be determined, and it needs to be clarified. Otherwise, we just accept the fact that FWC officers, Martin County officers, private, are there for no other reason than simple courtesy. Hey, please understand, you're in the wrong place. You're on somebody's private property. You're on the district works property. But again, onerous, I think we need to get to the bottom of what that is. Was it somebody ducking from bullets? You know, I mean, onerous is a very strong word.
I mean, Officer Smith came and reported on activity that they had out there. I never received any emails about, gunfights or anything like that. So I don't know what the onerous would have been other than just the hours and the extra work and, obligations that these officers have outside, whatever. But
The FWC mentioned money is sometimes that cure to put things in proportion of risk benefit. So,
Or it could be read that onerous here is not just PalMar, but all of the other off-duty works that
right.
Martin County has taken on. So it's sort of a double-edged sword. You don't know if it's specific to us or if it's just Martin County in general,
Right.
off-duty work.
Yeah, from the couple of times that I've spoken with Officer Smith, he seemed like if there was issues, he would have of that nature, he would have brought them up, I would think.
Well, I think if we're going to go forward with this, we need, obviously, seems like the day to get more information from
Yep.
people.
So I'll get with Officer Hudson's information and ask him to kind of send something to us so that we can bring kind of his outline of what his proposal would look like, to the next board meeting. And at least that's a starting point.
That sounds good.
Thank you.
All right, moving on to item number 9, update on email to FWC and South Florida Water Management District regarding target shooting. So at the last board meeting, we had the lengthy discussion regarding the target shooting, both the location of the target shooting, the direction of the target shooting. The board had asked that we start a conversation with both the FWC and South Florida. I sent emails to a couple different contacts that I had, the specific contact that Officer Smith had suggested, and also just contacts that we have at South Florida and Fish and Wildlife that we've dealt with over the years for various issues, just to give them a heads up that this has become a conversation. At this time, they acknowledged that we're having the conversation. We haven't set up any kind of meetings or anything like that. I know that I talked to Ruth, and she was going to put in a kind of a courtesy call to an attorney there with South Florida to kind of let them know the situation. I don't know if you ever got a response back.
So I did talk to one of the attorneys for South Florida Water Management District, and according to what he said, South Florida is very aware of what's going on out there, obviously. They have, from what I understand, limited authorities to do anything about it. We both, I mean, just, as two attorneys talking about the issues, talking it through, it's very, law enforcement issue. If it's happening in Martin County, it's Sheriff's Office issue. Fish and Wildlife obviously has the authorities to enforce those things as well. So for the regulatory agency, unless there's an issue of, damage to the works of the district, damage to water management land, or trespassing, it's a tough situation, and without identifiable, unless we can identify the actual people who are doing this, it's a tough situation for anybody to deal with. It's kind of like somebody's dumping litter on your on property on a right-of-way that you own as an agency, whether it's Palm Beach County or anybody else. And I mean, what are you going to do about that? And sometimes you just, as the owner of the right-of-way, you just have to pick up the trash. And there's not much you can do until and unless you find out who did it. That's kind of where we're at with it.
So it's a non-issue with us. Target shoot, I'm trying to figure out how target practice and these type of things have any effect on the works of the district. That was my question coming up. I think you answered that for us.
Right, unless
We don't deal with it.
Unless you can establish that there's damage to works of the district. So I think that, I'll tell you, so back in October, I believe, I met Mr. Mansell out at PalMar, and he gave me a tour. And one of the first things that we did when we were going through one of the gates is I was walking around, and I picked up a bullet that Mr. Mansell identified as, an AR-15 bullet. And he's, and the idea is that what we understand is that, folks are doing target practice out there. They're shooting down the canals with these high-range, firearms and whatnot. Is it damaging works? Is it damaging the canal banks? Is it damaging a gate? Is it damaging a culvert? Those are something that we could do something about, but who's doing it?
Well, I'll just end up saying the next agenda item is saying placement of signs. If you place any sign, any place in PalMar, it's going to be a target. I mean, they're even shooting the stop signs. I mean, what is the purpose of shooting a stop sign?
I don't know. It's destructive, but when those signs are 6 feet up in the air, the trajectory of that bullet is probably 3 miles. When the sign is down on the fence, it's probably, 30 feet. And I brought this up as a courtesy to one of the landowners, that he had to take cover behind his tractor, because what I'll describe is a projectile fired from FWC lands, trespassed by projectile over his head, and again, he had to duck behind a tractor. Now, again, who do we blame? Who do we stop from doing that? I don't know. I don't know, but there's got to be some way to reasonably address safety out there. Is it maybe FWC moves the gate to the corner of the canal instead of the dead end where the bullets are going to go flying down our easement? I don't know, but some creative idea to provide safety for people beyond the boundaries of the FWC managed properties. It's important, and I don't know that imminent is the right word, but it is definitely something that poses danger to district personnel, property owners, et cetera.
Yes.
Sadly, it doesn't seem like we have any authority.
No, we don't. We have to rely on others to help us out. The only impact I would say is there is some damage. And over the years, my son has collected a bundle of reloadable brass that has substantial value. Shotgun shells by the thousands, basically, can be found at any of these locations, depending on who's cleaning up and who's not. All of that lead ends up in South Florida Water Management District properties. And is that 50 pounds of lead? Is it 20 pounds of lead? With acidic rainwater conditions coming down on that lead, yeah, we've got a problem. So there is real destruction of property that's occurring, as well as, implied.
Yes, it is hazardous. Whenever they take a gun range and abandon it, all of that material is hazardous in the berm because of the lead.
So we're setting FWC up for a potential, it's not going to be a super fund, it's going to be a mini fund cleanup or
Yeah.
something, yeah. Or,
Well, I think, given the fact that there's not much we can do,
table it,
yeah,
kick the can down the road, as
I hate to say it.
come to say.
So
There's no motion to make.
right, there's no motion to make. The question is, do we want to keep this as a reoccurring agenda item, as a discussion, or just bring it back in the future if something changes?
If there's concern in the future and it's brought up by a board member, we'll bring it up again.
Okay.
Thank you.
All right. Moving on to item number 10, discussion on possible wording and placement of informational or safety signs. At the last meeting, it was suggested that maybe we put some kind of sign out there to warn about the shooting. I know that the attorney had said that she wanted to look into what language we could put out there. And like Mr. Higgins and Mr. Loma attested to, that any signs that you do put are likely to be destroyed relatively quickly. I know that in the years past, we put signs at the end of some of the canals. I don't know how long they lasted. TJ?
They're still there.
There's some.
A lot of holes there.
Okay, so that's what we're looking at. But so at this time, I would say I don't know what the board's desire is to move forward with the placement of signs.
I think they just become, in light of the discussion we've just had, they just become attractive nuisances. We don't need to add targets there.
It's a common sense type item that I'm not a hunter, but the hunters want to shoot things.
I know hunters that I know of want to do that. I do not know a single hunter that would randomly discharge his firearm into somebody's private property.
Yeah.
I know guys that like to kill and hunt and do things like that, but they are mostly very, very respectful of private property rights. See some eyebrows.
No.
Placement of tree
The
stands,
agenda.
feeders.
So at this time, it sounds like we'll go ahead and take no action. We'll go ahead and remove this off the agenda. Again, if at some time in the future, the board decides they want to look back into it, we can bring it back. But they would likely just be target practice. All right, moving on to item number 11, discussion regarding the installation of gates on district works at the landowner's request. This was brought up during, I believe, board member comments by Mr. Cutting at the last meeting to bring it back to this agenda, so I would turn it over to Mr. Cutting.
Well, I guess the point of the gate was not necessarily to lock and exclude people from use of district easements or private property. It was basically to provide a location, a barrier, and an identification of that easement, basically. If somebody has to open a gate to go through it versus just freely drive through an easement, there's a degree of consciousness that occurs there. Yes, I am I know I am trespassing. That gate is closed. There's a sign on it. It's like an open door on a house. You know, do you open through? I'd love to know what the legal opinion from our sheriffs is on going through a gate versus going through a completely open road or a open door. You know, but that would be my intent of where a gate could be placed and how. Does it provide some identification of private property, of district easements, et cetera?
Do you have an example of where one of these gates would be?
Sure. As you turn north on 7N, I think right now, I'm going to say it's Corey's signs. Is that correct, TJ? It's no trespassing. One right, one left. You know, it's, yeah, that's his opinion, but if there were a gate there that somebody had to stop and identify, then again, they would be consciously using that. Now, you know, again, pending litigation, et cetera, some of this may be just, again, future date. Well, if anybody else has any input, if we have any legal inputs, whether we have the authority to gate off easements that are identified as strictly drainage easements?
Well, it's such a hypothetical. I would say that, given the, ongoing litigation brought by the corporate landowner to obtain access, I think maybe we can have a discussion about that in the future.
Agreed, done. Thank you.
That was quick. Thank you very much. Okay.
Okay, moving on to item number 12, discussion regarding financial impact of damage to the works of the district and possible preventative matters. Again, this was a item Mr. Cutting brought up at the last board meeting to add to this board meeting's agenda, so I'll turn it over to him.
All right, I'm going to try to stay focused here, but this one is challenging as well. We have one corporate lawsuit pending. We have another lawsuit pending for easement by way of necessity, I believe this would be. If my limited understanding of the lawsuit as filed is taken in its most generous or most permissive form, any easement within PalMar, whether it has been recorded as a district water control or maintenance easement, or whether it has been recorded as that and a roadway, is going to be subject to ongoing traffic. And it's certainly not just my opinion as to whether it is going to be. We can look to the judge who said, basically, yes, you have an emergency injunction that has been granted because, amongst other things, there's a favorable chance that you'll win. So I'm going to take what the judge says, and my understanding and my feeling is that, can we approach the court through, again, I think the term is a amicus brief or a friendly letter?
Friend of the court.
Friend of the court letter that basically says, hey, when you're considering granting of this easement, somehow, please consider the financial impacts to the district or the damage that may occur to the district. And on the extreme side of that, maybe at some point, based on your review, based on the engineer's input, would we wish to join that lawsuit?
Okay, Ruth, you're up.
You're on deck.
So they're slightly different issues from a legal standpoint. The amicus brief is a little bit easier to talk about because, so an amicus brief is something that a party with interest in an ongoing litigation submits to the court to say, Your Honor, although the parties didn't bring this up in the litigation, we think that there's some other issues that you ought to look at. Our interest is, in this case, it might be impacts to works of the district, things like that, and we think you ought to consider this. Maybe in terms of narrowing a final judgment, if that's the case. There are no civil rules that speak necessarily to submission of an amicus brief at the trial court level. So what parties tend to do is they look to the appellate rules. It's probably mind-numbing to most of you, but for us, it's what we have to look at. And so one of the things, or there are 4 things you have to look at if you're going to submit an amicus brief, or if that's something that the board in this case would want to do. And we would have to say, okay, what are our interests in this litigation? And and I think that's where the law and, in this case, the engineering principles and the impacts from a maintenance perspective, they all have to come together and inform one another. So I can't just necessarily say, okay, these are our interests as the Water Control District. I would need to be informed by Mr. Higgins, I would need to be informed by Mr. Mansell, and potentially by property owners out there. What is the interest in this litigation? If the corporate landowner gets everything he wants, will that impact the Water Control District? How and why? The other thing is, how would PalMar's position, even if our works of the district could likely be damaged if the plaintiff gets everything he wants, how would what we have to say assist the court in making its determination? And like I said, that we would have to kind of sort through that, and maybe it's narrowing a final judgment in some manner, so it's just not carte blanche out there, enormously impacting the maintenance cost of the district going forward if the plaintiff gets everything he wants. And then the other thing, in a lot of cases, this isn't the tricky thing. In this case, it might be because of the nature of the parties and the relationship to one another. Is the court's going to want to know: do any other parties do they object to the amicus brief? Do they object to the court looking at this from the PalMar's perspective? In this case, with all the parties in the litigation, I think there's 4 or 5 at this point. PalMar would have to reach out to each of these entities, each of the organizations, and ask if they consent to the amicus brief. And obviously, in this case, the opposing counsel is usually the big hurdle in that. So that's the amicus brief. It's not binding. Nothing is binding on a party. It's just information for the court. It's the easiest thing to do in this circumstance if the board wants to look further at that. Intervention into the lawsuit is a little bit harder hurdle, because that is where, in this case, a water control district would become a party to this litigation. So you would be, subject to discovery. In other words, the plaintiff, and who knows, maybe one of the other defendants, may want to seek information that you have as a water control district. What are your communications? What are your easements? What are your records on these gates and these things at issue in the lawsuit? And you may, there may be people of the water control district, even past members of the board, that may get deposed. So those are kind of the things that you have to recognize. Even though you might become a party and you have a seat at the table and you get to argue your points, legal and factual, there are also some practical realities to that. So those are things that intervening, you have to really consider before you just make the decision to ask the court for that. And again, it's the court's decision. Just because you have a clear interest in the outcome of the litigation doesn't mean the court's going to allow you to do it. So, I try to stay pretty basic about it, but I'm happy to answer in more detail if anybody would like.
It sounds like until litigations are over, this is probably something that, not kick the can down the road, but we don't want to involve ourselves in anyone else's litigation.
I only disagree to the extent that the potential cost impact to the district would be substantial. And it is kicking the can down the road. There absolutely is, because the impact that occurs, I mean, we will have two ways to deal with it, as I understand. One is we take the position that perhaps the district does not have the financial responsibility to develop roadways. And particularly when you throw that public statement that goes into the easement.
We're not roadway builders,
Absolutely not. So
and nor are we,
can't do that.
nor are we supposed to be supplying
That's
that.
it. So we would have to possibly just simply ignore the works of the district and let them become bumpy and self-limiting, I mean, that's one alternative. The second alternative would be perhaps prepare and understand how those works need to be supported financially and to the benefit of the people along the easement. Not just to the district, but if somebody's got a house down on the far end, how does his financial?
There's no houses out there.
Pardon me?
There's no houses out there.
Yeah, I'm sorry.
And no, and please don't even
You're
bring that up in a discussion.
absolutely
No, there should be no structures out there.
If
So-
somebody's tent occurs at the very end of our easement, that person receives benefit. Should it be the district's responsibility to take money that we have collected from the chimney or from the far eastern section, which is under control by FWC? It just kind of implies that we would possibly stuck with an unfair distribution of our pro rata shares for one very small localized area. And again, it's my belief that we do have some interest in pursuing that, but I'm one of five, and we'll leave it basically at that unless I need to elaborate on.
I think we're good.
Yeah,
I think
okay.
we've covered it. And I don't believe that at this point in time, there's anything we should really be. It's always nice to plan for the worst and hope for the best. But I think any more discussion about this should be tabled.
Could I put forward one motion to allow our attorney to follow the case without any sort of intervention and just keep us informed?
I believe you probably already are.
I'll be happy to follow the case in more detail, and maybe at the next meeting, if there's something that I think the board ought to be aware of that's happening in the litigation, I will bring it up under the.
Perfect. If you
All right.
feel an action item is needed, we'll defer and hear what you have to say.
Thank you. Okay, I think we're good.
Awesome. All right. Moving on to item number 13, update on district attorney review of Caldwell and Passetti November 2019 memo. This again was part of our discussions later in the meeting at the last meeting. The memo is actually in the books on page 34 and 35. At this time, I turn over to Ruth to see if she has anything she wants to comment further on this memo that was adopted by the board. It wasn't adopted by the board on the 19th. It was sometime later, but that's when the memo was originally created.
Right. So I do remember this memo, and I think it was a well-written memo, and it basically says that PalMar Water Control District's authorities are limited to that which is in the special law and Chapter 298, the special law that established PalMar Water Control District. And the issue back then in 2019, which reoccurred, I believe, a couple of years ago, and that was whether or not the district had the authority to allow the public ingress and egress, or to issue an easement to the public for ingress and egress through a certain, I think it was right off the B line, that gate through the B line. And And Caldwell Passetti said, no, that you don't, you're limited to effectuate the water control plan, and that's about it. So that's what the memo says. And I agree with that. I'm glad the board adopted this as a policy recently, and I have no problem with it legally.
Any other comments on that?
It's a nice policy subject to litigation and future interpretation.
Okay. Thank you.
All right, moving on. Status reports. Legal, anything not covered in the agenda?
I'm thinking the board has heard enough from me today, so I think we've got it all covered. But I'm happy to answer any other questions that the board may have.
District engineer, anything further?
Yes, yesterday I spent numerous hours with Supervisor Cutting out in the field, and I was actually happy to see that not much has changed. It's not good, but not much has changed in terms of additional camps, and the biggest thing that you notice is the red herring of vehicle tracks going through wetlands, and it's horrible, but it's not getting any worse, I guess is what I'm saying. Another item I was asked to bring up, in cooperation with FWC, the FWC helps us police vehicle traffic on PalMar canal easements. And what's come up is a surveyor's right to gain access in the statute for surveyors, and it also applies to engineers. We've got the right to trespass. And so there's nothing that FWC or PalMar can do to stop a surveyor from going out and surveying a lot for BMN. And I'd like
Have
the
the
board,
Do they have the proper credentials? Are their licenses up to date, all of that? Are
yeah,
there-
that would be necessary, yes. But it's come up in terms of FWC's question on should we prevent him from taking a instrument crew truck up through canal easement. From my perspective, it's not enough traffic to warrant a concern, and it recognizes private landowner rights to survey their property. I also, as an engineer, can do the same thing, but I'm not going to abuse it. And the surveyor should professionally feel the same way. So FWC is asking for some direction on should they open up gate, in particular 7N, to allow a surveyor to go through to survey BMN property. My recommendation is yes, it should be allowed.
Comment that from what I've read about surveys, and I have close personal friends that are in the surveying business, they do possess that right. The benefit to the board is that by establishing some reference points out there, we may perhaps be able to borrow some of those corners and save in cost in the future. Is that a possibility?
Yeah.
So there's benefit to the board.
And I forgot to add, there's a limitation on that open access. It cannot cause damage. So if damage is caused by the surveyor, then the surveyor is responsible to repair it.
Well, the last sentence of the November 2019 memo says, "The members of the general public do not have a legal right of access to those easements which are dedicated in the district's favor and not to the general public." So how does what you're proposing,
Supersede.
well,
A licensed
Is it-
professional would not be considered general public.
I think a licensed surveyor would be. Not a landowner.
Ms. Holmes,
There's a specific Florida statute for surveyors, and
Yes, and surveyors, surveyors do have the right to go on to even private property to survey land, but, the limitation is damage here. So, that's just where it is. That's what the statute allows.
Does the surveyor have to provide, I'm sorry, Madam Chair, I have
Go right
a
ahead.
question. Does the surveyor have to provide certification and licensure in order for that request?
it should provide it if requested.
And is there, as we're allowing access across our easement, is there a requirement of certificate of insurance or anything like that while they're operating in their professional manner?
No.
Okay, and then how is it determined if the, I guess, is the individual attesting that they're out there for professional work and not just simply, I don't know, joyriding?
Yeah. They're not out there fishing and hunting.
Okay.
They're out there for a specific purpose.
Thank you for answering my questions.
I have a question, please. When you rode with Mr. Cutting yesterday, were we charged for it?
Yes.
How did that meeting come together?
It was at the request of Supervisor Cutting in order to gain knowledge of the district as a new supervisor, and I felt it was appropriate.
Fair enough. I think in the future, we should share that with all the board, that you're going to be out there as one of our vendors or as our professional. The reason I'm saying that is I would have liked to have rode light along with you yesterday because I had two areas.
Can't.
Can't do it.
Unfortunately, outside of an advertised meeting, you can't have two board members together
Yeah.
going over district business.
We can do it separately.
Okay.
You'd have to do it
I
separately.
think I've
with
been
him.
corrected on that before, now that I think about it.
Yeah.
Thank you.
Yeah, no problem.
I think what boils down to is that we cannot, we cannot not allow a licensed surveyor. The question is, how do they, and I guess specifically is we need to make sure that they're licensed. And your response to that was, they only have to show that if they've been asked.
Yeah.
Okay, so there needs to be a policy in place that if we're allowing a surveyor on property and they have to go through Works of the District or FWC or something else.
You can request that they show proof of insurance also.
Okay.
I think that's important. I mean, if we're restricted from not restricting, at the very least, we ought to have, a formal,
Formal
ask and then some formal determination of credentialing so that it's not abused. And then obviously the insurance, or, whatever certificates of insurance we need.
That's fine. Is FWC happy with that?
Again, Tom Reinert, Regional Director. Yeah, the reason I posed it to Mr. Higgins is because we've been on the receipt of numerous communications, both verbal and written, about not allowing vehicles through, particularly Gate 7N, because of the fact that it's a drainage easement, it's not maintained for vehicular traffic, and the amount of it was excessive. And so we quit issuing permits to that effect. And so before facilitating this access, which seems to be a lot, it's 1,000 properties, quote unquote, that I wanted to make sure before, because they have to go through an FWC gate. And I'm respectful of the rules regarding licensed surveyors. So I just wanted to get some direction from you, and I'm also seeking it from the South Florida Water Management District because they own the next 4 or 5 parcels, and their specific 40E rules prohibit vehicular access across their vacant lands. Now, I think I'm not going to speak to how they're going to react to that, because I have not heard from them. It's under discussion. So, But again, I don't want to stand in the way of a duly licensed surveyor.
Yes.
But I needed concurrence because I have no authority over the land north of Gate 7 Hen. That is your easement, and at least the first several parcels are owned by the Water Management District. So that was just my effort to try to get that sorted.
There needs to be a, identification, license.
Yeah, I mentioned that that could be a,
Register,
Sure.
vehicle registration,
Condition
so
of
we
the-
know what car's going in, I don't know.
yeah, so in conjunction with the Water Management District, I think we can come up with a few requests, simple requests to provide license plates, names of the surveyor, and agents, because the surveyor can bring, if I'm correct, Bob, agents or employees
Yes.
in addition to the licensed, state licensed surveyor.
Yes.
So it seems like a very large task, so I imagine there'd be, it's not just one guy with a thing, it's going to be a crew,
Crew.
multiple crews, and for many days, so.
And does South Florida Water, FWC, are you guys requiring an attestment that they're actually out there doing that work and it's?
We haven't formulated that process yet. I wanted to get input from the two entities that actually control the properties that Gate 7N allows access to.
And I apologize, Mr. Higgins, just for clarification, they have to be current, right? I'm not familiar with surveying and in the licensure of surveying, but you have to be current, I'm assuming, correct?
Yes. Yes.
All right, because I would hope that we would only extend that to the current survey. You can't be retired for 10 years and
The
No, no.
renewal.
hobby surveying, I guess. I don't know if that
If
exists.
you're not a currently licensed surveyor, then you're a member of the general public.
Okay.
To address Commissioner Hurd's issue, and then, no, they would not be allowed.
It sounds like we really can't deny access if they have.
Again, I just wanna
have all
make
the
su-
qualifications necessary.
Because of the past input that the board has given me, admonishing FWC for allowing traffic through there, I want to make sure I had some input from you
Correct.
before I was able to do that, because I didn't need another nasty gram.
That's good.
Thank you.
May I comment? Certainly.
Continued.
The TJ would, I assume, be our measure of is damage occurring, and that's something he can keep his eye on. For being man's sake, I certainly hope it is not 1,000 trips, but it is likely to be a few coming back and forth, and the washouts on 7N as you turn to the west are right now pretty rough. So might be pulling somebody out. Okay.
All right. Anything other from the engineer's report?
That's it.
Okay. District manager's report, we kind of went over one of my items, which was what you wanted to do in January, and it sounds like January will be, go ahead and cancel that meeting, plan to hold the February meeting.
Do you need a motion for that?
We haven't in the past, but if you want to, I don't have a problem with it.
No, I don't want to buck history here.
Cancel, hold Feb. The other item I'll bring up is, so we had been in contact many times with your old attorney's firm to try to get the physical documents that they still had in their possession over to Ruth. I had told them that as soon as they're ready, I will personally drive to the office, pick up the boxes, and drive them over to Ruth's office. They kept having people out, vacations, holidays, what have you. I finally got word about a week and a half ago that the boxes would be ready very soon and that I could come pick them up. And then they immediately, we actually were scheduled to get them earlier this week. But then they made a condition of that pickup. They sent me over an invoice just north of $8,000. I think it was like $8,250, somewhere in that range, saying that I must come with check in hand for the work that the hours that they spent putting the boxes together, and I must bring the check with me, or else they will not release the boxes unless I come with payment at time of pickup. Typically, this would have not been a huge issue, except for the dollar amount of $8,000 seemed high for that type of work, for putting together the boxes of these documents. And I ran it by our owner, our president, Mr. Wadraska, and he said that's a little high. I'd feel more comfortable if you ran it by the board. I know this is going to delay Ruth getting the boxes, and we checked with Ruth and let her know that, hey, we could pick up the boxes this week, but I'd have to walk over there with a check for $8,000 in addition to the, the work that they had done as your attorney to pick them up, and she understood that we wanted just to bring that up to the board first. So I just want to make you guys aware, the current plan, I was supposed to go get them on Monday, assuming that there was no issues with the board. She called me yesterday and said that the people are going to be out of the office on Monday, so I need to come by on Tuesday if I'm going to pick them up. But I would be going with that check in hand if there's no qualms.
Does the $8,000 invoice include an hourly rate and the amount of hours, or just give us a check of $8,000?
No, they did. They had a couple of hours for actual review by some of the actual attorneys, like Mary, and then they had a lower hourly rate. I believe it was $90 an hour. I'd have to go back and look at the invoice, but it was like $90 an hour for X number of hours of like staff work, compiling the boxes and what have you.
82 hours.
Yeah. Okay. So that was
They want
better memory than me.
They want $100 an hour? That's crazy.
And there are our records.
And there are records, yeah.
So that was kind of where Todd and I were coming from. Was we have thankfully had very few situations with turning over documents. Normally the documents are in our office, and normally we don't have to go pick them up from the attorney's office. This is one of the first times where the attorney has kept a large amount of the documents, the physical documents. Like I said, I've got most things in electronic, but we'd have to see what's in these boxes to see what I don't have. So that's why we felt like this was a discussion to bring to the board rather than just assuming that there wasn't going to be any qualms.
We've already paid to produce those records. They're ours.
I'm not happy.
That was our fear.
What would the method of retrieving those documents legally be in the event that we had a need for them?
I mean, you could sue them, but I don't know that that's advisable. I will say this, working for state agencies in the past, sometimes it does take an inordinate amount of time and effort to go through documents, especially when there's, like in this case, years. I don't know how long they were the counsel for the Water Control District. I'm guessing.
They were there before we were there, so at least a couple decades, yeah.
So there's a lot there, and probably generated and stored prior to the cloud and it being in existence. So there's a lot of paper to go through. I'm not justifying the cost. I'm just it's going to be a cost in order to get those documents, and they know it. They're lawyers. They're good lawyers. They know. But there also may have been a lot of effort that was involved. So, for example, if the firm had done a lot of memo writing, or if they were involved in the litigation with the non-ad valorem assessments years ago, I mean there could be a lot that they have to go through that they may feel is not shouldn't be part of the records transfer. I don't know. I haven't talked to them at all about it. So
Did they say exactly how many boxes there are?
They didn't give me a number of boxes. I told them that I had an SUV, and they said that I should be able to pick it up with my SUV. So I'm guessing that can't be more than a dozen boxes. I would think at most. I don't think I could fit more than that in my SUV. So, but they did not give me a firm number. No.
Another minor comment: are the documents in safekeeping now, and does Caldwell Passetti have a requirement to store them in safekeeping?
Well, everything that they have, it should, I'm not say everything, but most things, it's going to be attorney-client privileged communication that's in writing or attorney work product. And, you hold the privilege for those things, you as the client, not them, not me. So they have a duty of safekeeping and confidentiality to you as the client. So it should be, to make
So we either take advantage of free storage, or we pay the $9,000 and just sadly, pay the bill versus fighting over it, which would be probably much more expensive at some point in time and involve a compromise at some future date as well. So,
Madam Chair, I can relate it to when I took over as district engineer. The previous firm was Ingenuity, Shalloway, and they turned over to me probably a dozen boxes. I went through the material and saved 2 boxes, and the rest of it gave to Special District Services that's in storage, and I've not once had to refer to them. Just as a point of reference, I kept basically the historical water control plan material and the easement material, that sort of stuff, but the special surveys that they did and everything else.
Let's have Michael ask him if they'd reconsider giving us a certain amount of break on this thing and end it one way or the other. If they don't agree to giving us any kind of a break, pay the bill, get the paper, and let's be done with it. There's nothing, we're all business people. We understand there's no end to this, so.
Plus, if in the future, if we request something that they hold in the future, we'll get charged for an hourly fee for them to go and find it.
Right, yeah.
Well, we sort of,
Possibility of that, once they turn it all over, that we don't have it all? Is that what you're saying?
no, if we don't get it, if they store it, if they keep it.
Understood.
And in the
Okay,
future,
thank
we
you.
say, oh, we can't find this, do you have it? Then we get charged. It's like the county charges for public records requests. So, well, by hearing our meeting today, they know that they're going to get $8,000, so.
I will pick up those boxes on Tuesday, and I'll get with Ruth on dropping them off. You'll check your availability, see. Other than that,
Ouch is right. Paying for our own documents.
right. It felt weird to us, too. That's why we wanted to bring it. Field maintenance report, TJ?
I don't really have much difference. I got some pictures I took, and hopefully this will give you an idea of what Mr. Cutting was talking about, the heights of these berms out there. These berms, you got pictures?
Yeah, I'm trying to.
Can I swipe this screen to move them?
No, I don't think that screen is touch screen.
No,
No, it's not.
It's not letting
but
me-
there's a mouse.
Mine is next door. Well, I'll just flick the finger a little bit. You can flick it. But as far as, like I said before, as far as the washouts and everything, there's a lot of low spots that were made for water to come from the swampy area to the canals, what's over on the west side. And there's a couple over on the east side. And they're at the end of the canal, and where the people have been driving through the water, they've kind of washed out a lot of sand in that. It's just made it a little deeper. And I just wanted to show you, I have pictures of one side of the canal where it looked like when I was there. When I was there, it was a lot different than what it is now, as far as these berms and as far as these roads. Here's a side here of a canal. This is what it looks like. Go ahead and flick. Can you flick it? Oh, there you go. All right, this is what it looked like when I was there, right there. This is an outside berm, what goes around the whole outside edge of the works that we have the works. You can see how wide that is. You step out of the truck, you're going down the side. If you can't even get a bicycle by somebody. And that's the way it was all the way around that whole place. Because it was one way, all the way from Pratt Whitney Road in was one way. There was a couple places that you could pull over and get out of the way of a vehicle coming the other way, but it was definitely one way. Go ahead. This here is a picture of what's happened. This is what's happened out there as far as the outside berm. This is, to me, and to the contractors I took out there, this was done with a grader. This is shortened up the berm, you know, from maybe 4 foot high down to 1.5 feet in places. I mean, you can see how wide it is now. This is where 2 vehicles can cross. I witnessed none of this because I wasn't there for a couple, so I can't say who, what, and when. I'll leave that up to everybody here. Go ahead to the next one. This is coming into the place. Those are cypress trees on both sides of my truck. And as you can see, that's all been just graded down. And this is all mainly for access for these people, you know, to cross each other. Go ahead to the next one. This is what it looked like when I was there. Not even that much dirt. This is wear and tear. Right there, that little bit of dirt. Every person that goes out there goes down this road. And that's what it looks like.
This is a current picture?
Yeah, this is all current pictures. See, the one side of the canal, you know, you're out there.
Yeah.
Lou knows he's out there. One side of the canal's been graded, one side's like this. All right? I have no problems with washouts when it's like this. As you can see, that grass on the edge, that grass is very important to be there. And when it's not there and everything's turned into dirt, when it rains out there during the rainy season, it creates a lot of damage. And which really it's not bad right now. Okay, go ahead. As you can see, I took a picture across the canal there to see where that road is, how it's been graded. There's not even a grass spot down the middle. It's just been graded. Where I'm at, go ahead on over one more. Where I'm at is looking the other way. See that picture there? That's looking the other way. From where I just took the picture across the canal to the other road there. This here, I used to own a piece of property on this, right on this. This is the way, I've owned property out there since 2004. And I've been out there many, many times. I used to hunt there a lot. I was out there all the time when I first bought land. But this is a canal that hasn't been touched. And if people come in and say, oh, well, we got wear and tear, let me tell you, every person that has a lot out there who's using their lot is using this road. Because they're riding around the place. They're not, you know, they're not just riding into the woods, you know, and just tearing up everything. Go ahead. This is the main road coming in and out, which should be half that width. As you can see, you see how flat that is?
Whereabouts is that?
That is coming in from Pratt Whitney Road,
Emerald Pratt.
Gate 1.
First mile or after the first mile?
First mile. This is a road coming in. I mean, it used to be just a berm, one-way berm, going in, just like that picture I showed. Now look at it.
I'm going to just relate something that I heard from a property owner was, perhaps it was last year, there was an 1.5-hour traffic jam getting out of PalMar due to the sugar sand pit.
Well,
It's about 3/4 of the way back.
I don't even care about that. There shouldn't have been no sugar sand. It should look just like what I'm showing you with the grass. It should have been one way, and there wouldn't have been nowhere near the damage that we would be experiencing.
Absolutely. There is,
And you can see, Mr. Higgins, can you see that? You see how flat that is? I mean, that is flat. That's not sign of damage from people driving in and out. Looks to me, look to the contractors who I took out there, like it was graded. I don't know when, I've only just got the job back, but This is, look on the side. Look how high that berm is. That's a berm. Look over on the side there where the grass is at. That berm is this high now. When it was 4 foot high. You know what I'm saying? So this thing has been like this off of a berm that was this high.
Does any of this impede your ability to get out and inspect?
No, this here is at the corner. No. This is answering your questions about the heights of the berms.
Okay.
I'm doing my legwork as a supervisor of maintenance and eyes, ears, and mouth to the board.
Okay, but
Okay?
my question is does it take you a half hour to drive the district?
No.
Or does, when it
No.
gets rough like this, does it make you
No.
incur more time?
No. I have more problem with the people shooting down the berms than anything.
Okay.
But this is at the end of that 1 mile point 2, right at the end where you make when you come in from gate 1 and you drive all the way to the end of that, it's 1 mile point 2, and then you got to take a right. There's no berm there. Look at it. That used to be 3 to 4 foot high. You know, and this is what I'm answering your question because you brought it up. And I'm telling you, this is not from wear and tear. This has been done. Go ahead. This is another road. As you see, what I'm taking a picture off of is all dirt. I'm looking down a road the way all of them should look like. All of them should look just like that with the grass. Go ahead. I'm looking down a road there. All should look just like that. This is a camp over to the right. Go ahead. This is where the washout was fixed at that crossover where I came in and I showed you the pictures of the bad washout on both sides. This has been fixed. You can see the tracks right there on the left bottom there of where a bobcat went in there and did that. I was out there Saturday. I was out there yesterday.
Where did the dirt come from, TJ? That they fixed it with? Where did the dirt come from?
They just dug it off the sides. You know, they didn't pull it out as you see in the water.
It's from the berm itself.
It's from the berm. But you can see in the water, that was where my problem was getting a sub. I needed a sub with a backhoe to get that out. Now, I can't even drive a backhoe down there to get that out, but the washout was fixed. There's, yes,
So, TJ, how many more slides do you have?
go ahead.
No, the only reason I'm asking is and from the interest of time.
Okay.
We have a complete perspective of what you're saying.
Okay.
And what's happening is that somebody is bringing in heavy equipment, somebody is grading the road, somebody is putting sand down.
Right.
None of these are supposed to be happening. So what is our power as a board to protect the works of district and this so that we don't have washouts, so there is grass on the berms? What is our position here?
What I want to ask is for security reasons, I live 25 minutes away from the place. 25 to 30 minutes. I want the board to approve me getting some satellite cameras where they come as a text to me. And I can kind of keep an eye, it'll probably bug me to death, but I could probably kind of keep an eye on if somebody is out there doing something to our works, because
The only problem with cameras is if they're not camouflaged.
I know all about it. I know
they're
all
gonna be
about it.
Shot to
This
hell in a
ain't my first
handbasket.
rodeo. I've been in them woods all my life. And as you can see, all that dirt there, that's the way it looks like going that way, but if you look the other way, you can see all the grass.
How many cameras are you asking for?
I could probably get a 3-pack, and I want to spread them out. And I have a couple of cameras myself.
Lost?
Huh?
Lost?
Well, hunting season's almost over, so they ought to be on sale for some spy points, the small
Lost?
ones.
How much are you talking, TJ?
Probably, I don't know, probably $200, but it costs to for the pictures.
Sure.
Be sent to me, which I can run through my business and just bring in put it upon my bill.
You're thinking with these cameras, you could give us additional information that we could use to make decisions.
Well, certainly, because before we fix these berms, I think we ought to catch whoever's doing it.
I think, TJ, we're all on the same page. We know what you're showing us is the devastation that's occurred from use that's not supposed to be out there. And if it's okay with the board, I would say yes to the cameras. I just hope that you can put them up in a
I'll
manner
try.
that,
There's cameras all over the place. I don't think somebody's gonna know whose camera it is.
Agreed. I have the spy points. They are affordable. You get 500 free pictures.
Well, I don't know about free. They are
yeah.
when you first
No.
buy them.
Well, you get, yes, you pay for the camera and then you get a limited amount of
Yeah,
pictures free.
and then you start paying.
Every month, if you want unlimited, you pay more.
If you want to be reimbursed for the cameras, what amount are you asking for today?
Well, I'd have to get it all set up, but I'll pay for it, and I just want to be able to get paid back. I can give him a bill, and I'll pay
Yeah,
for
we
it out of
understand that,
business.
but it's an
I'd say
expenditure, am I correct?
Not
to get it all,
$800?
to get it all started, probably $350, $400. I'm not sure how much they are. I'm not going to run out right this minute.
well, let's
but
give you a not-to-exceed price of $500.
that would be fine. And whatever I spend to buy them, that's just a cover. I'll put it in what my bill is.
We need a motion for that.
Yes, please.
Yes.
Not to exceed, motion to authorize TJ to buy cameras with a not to exceed of $500.
So moved.
Second.
And that's only if y'all care.
Oh, we can.
All those
Usually,
All in favor?
Aye,
nobody
All opposed?
cares.
Okay.
we do.
All right, TJ, so,
If I
yeah.
may add one minor quick point to this, a drone survey. Bob, do you see a value in having a recorded drone survey done very occasionally, once a year?
The county does.
Yeah, we fly over.
We do?
I flew over with the
Resolution
sheriff's
is
helicopter.
sufficient enough to,
You can read license plates.
oh, perfect.
It's up there.
Yep.
Thank you, TJ.
Good enough.
All right. Moving on to, well, we are not going to have a Martin County Sheriff's Officer update. Need to go ahead and remove that from the agenda going forward. Administrative matters, financial reports. The financial report's in your books on page 37. We're early in the year, so, tax bills just went out. We haven't really received any of the revenues yet. I would imagine by the time we come back in February, the majority of a large portion of our revenues will be in there. If there's any specific questions, I'd be happy to answer them. Again, the box at the bottom shows that coming into this year, we're basically starting the year with about 1.9 million. That's kind of where our reserve fund sits right now. Consider invoices. The invoices are in your books on page 38. I will point out that 10,000 for Caldwell and Passetti, that is not inclusive of the 8,000 for record storage. That's their last two. They were a little behind on getting us their last two bills for the last 2 months that they actually worked. So that's actually for months that they were actually still the attorney. The 8,000 will be one additional invoice that's not included in there. Because we just got that, like I said, about a week and a half ago. It wasn't included on this. If there's any other questions, I'd be happy to answer them. If not, we just look for a motion to approve the invoices.
Go ahead.
So moved.
We have a motion, second. All those in favor?
Aye.
All those opposed, motion carries. Landowner items. Are there any landowners? Mr. Gaza?
Morning, Jack Gaza, landowner. A couple things. Number one, Commissioner Hurd, I don't want anybody spraying out there either. I own a lot of land out there, and I don't want you spraying on my land. All the canals, all the easements, if they're there or not or whatever, and every single roadway is owned by someone other than your board. Whether it's Martin County, Palm Beach County, South Florida Water Management District, myself, or other private landowners, that's all someone else's land that PalMar has the ability to use for drainage purposes. Let's not forget that. So when it comes to spraying vegetation and putting poisons into the ground on other people's property, let's take a little more responsibility about the actual property and the actual landowners and the private property rights. Number two, I'm concerned about cameras. For your sake, this is a government agency, and you're proposing, you're just authorized, you did it, to take pictures of people. So TJ can watch it. You're going to post cameras where you know there's other people driving around, walking around, who knows, maybe swimming in that canal. Maybe somebody goes skinny dipping. Now TJ's got pictures of someone on their phone. I don't know if that's something your board wants to get involved with. Maybe it's okay, maybe it's not. If you decide to do it, I'd recommend making sure you know where the cameras are and that they're posted to trees or structures that are on properties that you have the permission. For example, maybe Martin County or South Florida Water Management would give you permission to put the cameras on their property. Don't put them on my property. I thought there was one more thing. Oh, as a landowner, who do I reach out to if I have a concern? Do I reach out to the elected officials and see if one of the supervisors will put something on an agenda? Because now I don't know. I didn't mean to cause a problem, but I think, there's a lot of landowners. This is an elected board, somewhat. 2 are elected, somewhat. And I think landowners should be able to have a clear path immediately who to reach out to for an issue.
Mr. Chair. I would say contact our office, because our office doesn't get paid by the hour. We have a flat monthly contract. So you contact the management office, which going forward would be Andrew, and then he can relay it to the board/professionals, depending on what the situation is. But that way, it's not incurring additional costs that haven't already been, approved by other budgets or whatever.
So reach out to Special District Services.
The management company, which is currently Special District Services, yes.
Okay. All right, and as far as the vacating of the easement, to be clear, it has nothing to do with ingress-egress, nothing to do with any pending litigation. It is specifically for drainage purposes, which was the reason why it was brought to this board, as this is the water control district that is in charge of drainage over that 60-foot stretch of land. I reached out to FP&L and got their approval to vacate easement as far as power. The utility companies that are in that area, they would vacate as far as their utilities. PalMar Water Control District handles the drainage. They are in control of that portion of the easement. Martin County is responsible for the ingress-egress portion. So each different government agency with vacating an easement or a road or abandoning, or however you want to say it, is responsible for a different aspect of that. And I'm obviously going to have to do some more homework on the government's, those agencies' responsibilities as far as timely responding and working on it. I know these things take time, and I didn't mean to blindside anybody, but this is an actual request. The property is, there is no zoning, and it has future land use agricultural. I have 9-month-old calves at my farm that I need to move or sell. And my goal is to use the property out there in conjunction with the future land use, which is agricultural. But in order to fence the property, I can't fence in someone else's easement. So to fence off 1.25 acre lots for cows or cattle, it won't work. So that's the goal out there. I'm not trying to pull the wool over anyone's eyes. I'm trying to use the property for the future land use, agricultural, as designated by Martin County. I can't do that for cattle with single acre lots. That's the reason behind trying to put more property together out there.
Thank you.
Thank you.
And, we don't have a policy for time for landowners and whatnot, and I know that at the county, we have a 3-minute time limit. And I would like to add that to the policies and procedures, that there be a mechanism for comments. We allow 3 minutes at the county. What do you all allow?
3 minutes.
3 minutes. So
Yeah, we have various districts. Some have that policy, some don't, and I've seen it 3, 4, and 5 are pretty much the standards, so.
So we'll go with 3 and see what happens.
All right, any other landowner comments? Any comments from the public for items that weren't on the agenda?
FWC, do you have anything else you want to add? No. Okay.
Any board member comments?
I have one.
Okay,
Thank you. I'll miss you.
thanks, Lou.
Happy holidays.
I saw Commissioner Hurd just stepped out. I don't know if we want to give her a minute. I don't know if she had any comments. No, she's good. Any other board member comments? Hearing none, we'd look for a motion to adjourn at 12:03.
So
Perfect. Thank you very much.
Thanks, everybody.